Buckley, the State Coordinator of Alaska, and I'm very glad to welcome our Unit 1 judges and the timer myself, who can sit right here. Thank you.
Good afternoon, Nevada. My name is Barry Anderson. I'm an Associate Justice on the Minnesota Supreme Court. It's all good. Don't worry about it. Go ahead.
Hi, I'm Miriam Memar Sadeghi. I participated in the Lead the People program the very first year it was offered. And I run an organization that provides civic education to people living in Iran, which is where I'm originally from.
And I'm James Rice. I'm a legislative assistant for U.S. Senator Chuck Grassley of Iowa.
If you'd be so kind as to introduce yourselves and your faculty and advisors.
Good afternoon. We are Reno High School's Unit 1. My name is AJ Falstage, and I will be attending the University of Nevada.
I'm Danica Matthew, and I will be attending Arizona State University.
I'm Ariani Chalapali, and I will be attending Duke University.
I'm Jessie Fuchs, and I will be attending Boston University.
Hello, my name is Emerson Casey. I will also be attending the University of Nevada. Our teacher is Mr. Richard Clark, and our unit coach is Mr. Brian Carlin.
All right, very good. Well, we're here today to have a conversation on Unit 1. What are the philosophical and historical foundations of the American political system? The question that you have been asked to answer, we're going to have a conversation about, is number 3. Why have the Magna Carta, the Petition of Right, and the English Bill of Rights been called landmark English charters of liberty? What important constitutional rights did they establish? How are these 3 charters of liberty related to natural rights philosophy? And finally, how are these charters of liberty related to classical republicanism? Is the timer ready?
Yes.
The timer's ready. We're ready to hear. Go ahead and begin.
Dean of Harvard Law School, Aaron Griswold wrote, "The Magna Carta is not primarily significant for what it was, but rather for what it was made to be. The Magna Carta, the Petition of Right, and the English Bill of Rights have been called landmark English charters of liberty because they asserted rights and added to Britain's unwritten constitution after times of government abuse. However, they have also directly influenced the U.S. Constitution, the American Charter of Liberty."
The Magna Carta established the constitutional concept of rule of law by stating, "No free man will be imprisoned except by the law of the land." The Petition of Right reasserted the idea that no individual, not even a king, could act against the Great Charter. The English Bill of Rights echoed this sentiment by arguing that King James II had unjustly suspended the laws simply because he had regal authority. Article 6, Section 2 of the Constitution incorporates rule of law by proclaiming that the Constitution and subsequent laws are the supreme law of the land.
The 3 documents also establish the constitutional right of a fair trial by jury. Both the Magna Carta and the Petition of Right guarantees a trial by judgment of his peers. In the English Bill of Rights, Parliament protested that corrupt and unqualified persons were serving on juries. The founders were influenced by these documents, as is evident in Article 3, Section 2, and the 6th Amendment, which both guarantee trial by jury.
Inspired by Chapter 20 of the Magna Carta, both the Petition of Right and the English Bill of Rights assert that excessive bail ought not to be required, and cruel and unusual punishment will not be inflicted. The 8th Amendment reiterates this concept verbatim.
Thomas Hobbes and John Locke's philosophies were directly inspired by events occurring during the writing of the Petition of Rights and the English Bill of Rights, respectively. All 3 charters of liberty exemplify the natural rights idea of a social contract, because nobles and eventually members of Parliament gathered to demand protection of rights by a governing body.
The documents also protected the natural right of writ of habeas corpus. In the Petition of Right, Parliament declared that no cause was certified for the people's imprisonment except by the Majesty's special command. Article 1, Section 9 of the Constitution holds that the writ of habeas corpus may not be suspended unless in times of necessity.
Natural rights philosophy is also closely related with the concept of due process, which has its origins in these 3 British documents. In Chapter 52 of the Magna Carta, the nobles declare, "To anyone whom we have deprived or dispossessed of lands, liberties, or rights without the lawful judgment of his equals, we will at once restore these." Due process is evident in the Constitution in the 5th and 14th Amendments, which declare, "No person shall be deprived of life, liberty, or property without due process of law."
As Professor Howard describes, American constitutional law has expanded due process to include substantive due process, which focuses on the content of the law. In the 2015 case Oberfeld v. Hodges, the court held that laws banning same-sex marriages in Ohio, Kentucky, and other states were unconstitutional because they violate the due process and equal protection clauses of the 14th Amendment.
Finally, the Charters of Liberty are related to classical republicanism, philosophy that emphasizes the importance of the common good and working together. Chapter 60 of the Magna Carta holds that people will follow the laws to preserve their relations with their own men. The Petition of Right declares that the king and his ministers should follow the laws for the comfort and safety of the people and the prosperity of the kingdom.
Classical Republican Aristotle believed that if a country could combine rule of the many with rule of the few, it could create a stable, mixed constitution. The nobles demanded rule of the many by asserting, no scutage shall be imposed upon our kingdom unless by common council. In the English Bill of Rights, Parliament demanded that the king obtain their consent to levy money and raise a standing army. Article 1, Sections 2 and 3 established representative government, a key part of Aristotle's mixed constitution through a House and a Senate.
801 years of history.
25 barons.
3 charters of liberty.
2 houses of parliament.
Leading up to 1 constitution. Thank you.
Very good. Let's start with the Declaration of Independence. I'd be interested in knowing your opinion on the similarities and differences between the Declaration of Independence on the one hand and these charters that we've been discussing today.
The Declaration of Independence is highly similar to the Magna Carta in that both declarations were essentially just declarations of rights, and at the time they weren't enforced. For example, the Magna Carta was not enforced long after King John, and additionally in the Declaration of Independence it says, we submit these facts to a candid world, so it's mainly a declaration to the world that wasn't necessarily enforced until later. For example, Abraham Lincoln referenced that in his Gettysburg Address.
The Magna Carta, just like the Declaration of Independence, is a universal document. It's not targeted towards one country. It is actually a declaration for human rights, as my colleague kind of alluded to earlier. We can see this in Chapter 9, 12, 39, and 20 of the Magna Carta, where they all relate to some type of natural right.
Another similarity is the influence of these documents have had on other countries. For example, the Magna Carta has influenced both our Constitution and other countries, and so has the Declaration of Independence. For example, Vietnam had parts of the Declaration of Independence in their Constitution verbatim.
The Declaration of Independence and the Magna Carta are radically different because the Declaration of Independence was something that was intended to set up a nation so the nation could forge treaties and alliances as established by the Franco-American Treaty of 1777. And the Magna Carta was intended to just establish a body of rights.
The Magna Carta and the Declaration of Independence are similar because the Magna Carta is highlighting what the king at the time, King John had done wrong, and the Declaration of Rights also points out what King George III had done wrong against the colonists.
What was radically new about the Declaration of Independence?
Nothing was necessarily radically new of the Declaration of Independence because it was heavily influenced by the Magna Carta, the Petition of Right, and the Bill of Rights, all within England.
I disagree with Emerson. There was a great deal that was radically new about the Declaration of Independence. For example, this was the first time that a group of people who had been in the colonies and had operated under salutary neglect were actually establishing themselves as a collective nation state, and they had to do this through the Declaration of Independence. And in the end it says, we pledge our lives, our honors, and our sacred honors. So we can see that they were establishing a collective nation state.
How about the idea of consent of the governed? Is consent of the governed the same in the Declaration of Independence as it is in the landmark charters of liberty?
Consent of the governed is the same and different depending on which landmark charter. For example, in the Magna Carta, it was 25 barons who came together, and so that's not necessarily consent of the governed because it was mainly a higher class, and additionally they signed it at the tip of a sword. But it is often very similar to the English Bill of Rights, where they said that Parliament did need to have this parliamentary sovereignty, and so that is the consent of governed as is compared to the Declaration of Independence.
I would agree with my colleague, and I would say that the Declaration of Independence is more of a John Lockean social contract where we all come together under a compact to have a social body governed and have the consent of the governed to actually have a government and have rule of law.
Well, but if it's a John Locke document, doesn't that make it very different than the great charters? I mean, Locke comes along after the charters.
He does come along after the charters, but natural rights is just human rights. These are fundamental rights that all humans, I would say, feel. And Thomas Hobbes even kind of talks about this in The State of Nature, that even when a group of body of people are around they select one person, but so we can see a type of structure of government already forming.
So when they wrote the Great Charters, going back to Magna Carta, did they see themselves as asserting natural rights?
They did see themselves as asserting in many of these natural rights. For example, Chapter 39 of the Magna Carta says that they must have a jury of their peers and must be ruled by the law of the land, which even relates back to Article 6, Section 2 of the U.S. Constitution, which declares that the United States laws will be the law of the land. And so those are natural rights like a trial by jury and the right of sovereignty. And so even if they didn't necessarily understand that it was John Locke's rights, they were alluding to the same concept.
They did this in Chapter 1 of the Magna Carta by implying that the Church of England will remain free and inviolate forever. And that to me means freedom of conscience and freedom to practice religion. And this is reflected in our own Nevada State Constitution in our Article 5, in which it states that the freedom of conscience will remain free and inviolate forever. And this is also reflected in the United States Constitution in Article 6, Section 3, in which they state that no religious test shall be given to any official in government.
Is there anything relevant about these charters today?
There's absolutely a great deal relevant. For example, today we can see in Guantanamo Bay, as well as how we deal with terrorism, that we do not often give habeas corpus as well as due process rights to these terrorists, and that's what the Magna Carta established was habeas corpus. So if the United States is not following these today, it's something that they definitely need to look back on.
These charters are incredibly relevant today, especially the Magna Carta, because it was not followed at the time that it was written. So it expresses this idea that even though rights are written down, they're not necessarily honored. And today, North Korea has a constitution, and it declares that the people will have freedom of press, freedom of speech, but obviously that is not honored.
Thank you. Well, very strong performance, and I learned a great deal today. This is a great opportunity. So let's talk just a little bit about some of our discussion here. I really like the comment about the Declaration of Independence being more of a John Locke document. I think that's absolutely right. It's an expression of natural rights. The question here, I'm not very fond of the question, I have to say. It says, how are these three charters of liberty related to natural rights philosophy? It's not at all clear to me that they are. And the answer that you gave to that question, I think that was from my colleague here, was dead spot on. But I don't know that it fits with what they're looking for. It's very difficult for me to figure out what that is. So I thought that was, and I was trying to push you a little bit on about the natural rights piece, and I thought you handled that very well. I really like the reference to the Nevada State Constitution. Too often we forget that state constitutions are the source of additional rights. In Minnesota, for example, a motor vehicle stop, a motor vehicle arrest for a minor traffic violation citation does not automatically trigger a right to search a vehicle, which is contrary to a United States Supreme Court precedent. But it's all right because it's grounded in the state constitution. You recognize the very important things there.
I was also very impressed with your reasoning and the examples that you brought were disparate, and the fact that sometimes you disagreed with each other within the panel, I thought allowed you to make many arguments, and that was positive. I think there was clear thread of argument throughout in terms of how you see the charters of liberty. I like very much the point about North Korea in the line of work. In the line of work that I'm in, it's extremely important. We do civic education for Iran. We have to constantly talk about how the law is actually not protecting you, even though it is in the wording of it. It is, but it isn't in practice. And so what can you do? How can you use legal protections in those kinds of situations? So there's so much that happens that's, as Montesquieu said, is the spirit of the law that gets created when you do in fact have a democracy.
So I thought you talked about how some of these rights, like due process, had their origins in these charters, which I think is a good way of putting it. They sort of have origin, but then there's history to it. Although then I think at one point it was mentioned that the Magna universal in relation to natural rights. I think that's kind of retroactively imposing natural rights philosophy on something that I think was more specific to its time and was not maybe not intended as being universal. There is sort of this subtle distinction between the rights of Englishmen that they saw as their historic right being from England that then later influenced the natural rights philosophy arguably, or maybe it didn't, but it at least isn't the same as the universal natural right. So I think that's a distinction to keep in mind. But otherwise, I mean, I thought your description of sort of the history of how this worked was very good. I would also maybe ask my colleague if your state constitution is the source of rights, or if it simply recognizes the rights.
Right, recognizes rights. Exactly right. Yes, thank you for what he's doing there is he's catching. I was on somebody earlier today for talking about this. He's catching me making the same mistake. So let me just say about the. I'm going to disagree with my colleague a little bit on the business that he was discussing here, in the sense that I understood you to be making the point that the Magna Carta has become a universal document, even though it wasn't clearly intended to be so. And to the extent you're making that argument, that's absolutely true, because that's what Sir Edward Coke did. And it's interesting to remember, the timekeeper here is going crazy, she wants us to get going. So it's interesting to note that King John himself did not pay any attention to the Magna Carta, and in fact immediately calls on Pope Innocent to reject the thing. So your point, Mr. Faustus, am I pronouncing that right?
Yes.
Your point about North Korea extends to King John too. So thank you all.